Hi and welcome to this week's Hamara Kanoon video. Today the topic of discussion is ADR or Alternative Dispute Resolution Mechanisms. Now this term ADR is very popular in India and it's only growing popular by the day because we know that there is a serious backlog of cases pending in the Indian courts, both at the Supreme Court and at the High Court level, which means that today if you have a dispute and you want to go to a court, it may take you forever before the final decision comes out. People are getting extremely frustrated by this entire process, and of course there are many people who are thinking in the direction of how to resolve this backlog of cases. But what do we do in the meantime? So today, if you have a dispute which is absolutely hot and simmering, what are your options? Now in this video, I have one simple agenda, which is I want to explain 4 terms to you, which are legal terms of course, and they have legal implications. All these 4 are different types of alternative dispute resolution mechanisms. Alternative to what? Well, alternative to the court system. And what are these? These are dispute resolution mechanisms. So simply put, if you are an individual today who has a legal issue with another party, what are the options that you have if you don't want to take your dispute to a proper court of law? Well, you have 4 options. And in order to understand the conceptual difference between these 4 things, it's best to see them as if they were lying on a spectrum. A spectrum on which you have negotiation at this end, and then you move to mediation, further on to conciliation, and then arbitration. It's a spectrum which denotes how similar or dissimilar are these ADR mechanisms to its parallel, which is a court system. So while negotiation is very unlike a proper court system, and arbitration looks the most similar to it. But of course, all these 4 play out outside a court system. So let's briefly understand what these 4 different terms mean. Negotiation is a process where parties at dispute decide to come together and they decide to try and resolve their dispute by means of mutual negotiation. They can or they cannot, it is their choice whether to appoint an independent person as a negotiator. Even when a negotiator is appointed, the negotiator plays a minuscule role in trying to get the parties to a common understanding. But a negotiation in any way is not governed by the law. It is entirely the discretion of the parties how they want to conduct the proceedings and where they want to conduct it. Of course, it may require some professional expertise in ensuring that parties put their emotions aside and just focus on the core of the dispute. At Harvard Law School, they have a wonderful world-class program on negotiation which teaches people who undertake this training to understand and learn about how to bring parties at dispute at a common understanding. In India today, the government is also making attempts in this direction, but these are very much in their nascent stage. Now moving further, if the parties think that, well, they cannot just resolve the disputes by themselves or by this largely independent individual, they may decide to go for mediation. Mediation is a process where the parties decide to appoint an independent third person, who is an individual, as a mediator. Well, the mediator will try and speak to both the side of the parties independently, and then the mediator will also bring the parties together to try and resolve the dispute. The mediator and the parties together may lay down the rules of procedure that they want to be bound by. The difference between negotiation and mediation is that in mediation, the third person who is the mediator plays a relatively and comparatively much more active role in trying to solve the dispute. At the end of mediation, the parties may draw what's called a settlement and the parties may put their signature on it. However, unless this gets recognition from the court, the mediation per se is not a binding proceeding, which means unfortunately, even after the parties have spent considerable time in trying to come to some terms of settlement, if one party decides to still go to a court of law, well, the other party cannot prohibit the party from doing so. In order to take care of that, we have the next 2 types of ADR on the spectrum, which is the conciliation and then arbitration. Conciliation and arbitration have been recognized by the Indian law, and we have an act for it which is called the Arbitration and the Conciliation Act of 1996. Now, This act lays down for the first time, and therefore was considered to be a leap as far as ADR in India is concerned. It lays down specific steps of what needs to happen in mediation and arbitration, in conciliation and in arbitration. It says that, well, in a conciliator may require first that the parties submit to the conciliator written proceedings of what is at stake, what is the dispute that they have. The conciliator may also require the parties to submit exact issues which are at dispute between the parties. Once that happens, the conciliator can take everything on record and start speaking to the parties. The conciliator per se is not bound by the Indian Evidence Act or by the Civil Procedure Code. The conciliator, however, can lay down some rules for the effective functioning of the proceedings. However, the parties may still feel that the outcome of conciliation proceedings does not have the kind of binding value, which means, well, for a lot of practical purposes, it could look like a waste of time. If the parties want a binding agreement, it's best that they go for what's called an arbitration. In arbitration, which is a recognized way of ADR in India, parties decide to nominate or appoint an arbitrator. They can either mutually agree on one individual who serves as an arbitrator, or they may both appoint one person each who together then appoint a third arbitrator. Now, once the parties decide that, well, as part of a contract, if there is a breach on either side resulting in a dispute, the parties agree or intend to refer their matter to an arbitration instead of resorting to a court of law. There can either be a proper arbitration agreement that the parties can draw, or there can just be an arbitration clause in the contract that governs the parties. In either of the cases, the moment there's a dispute, if one of the party goes to a court of law and the court sees that the parties do have an arbitration agreement or a clause in their contract, the courts will refuse to entertain that matter, and the courts will say if the parties intended to refer their dispute to an arbitration, then an arbitration is the right forum for parties to resolve their matter. The parties may send notice to another party and request that they appoint their arbitrator at the soonest, at the earliest possible, in the earliest possible time frame, and once that takes place, then the future proceedings are governed by the Arbitration Act. The Arbitration Act very categorically lays down what will be the different steps and how the matter will proceed. Once the arbitrator gives his order, the arbitration order, it has binding value and it will be recognized by all the courts in India. So it's called an award. It's an arbitration award that's given by the arbitrators, and it's fully binding on the parties. So, we can also have, in fact, a separate video wherein I can take you into details on the Arbitration Act, and we can discuss some of the nuances under the Arbitration Act. But in this video, the idea was to tell you what are the different forms of ADR generally. Well, why are they so important to discuss? Because even the law in India today, if we look at different provisions, for example, Section 89 of Civil Procedure Code says that whenever a civil court has parties before it and thinks that there is room for settlement between the parties, it is a duty of the civil court to come up with some issues and refer the parties to settle on those issues by resorting to out-of-court proceedings. Similarly, we have some specific orders like Order 27, which says that in any case where the government is a party, Rule 5B particularly, in any case where the government is a party or a public officer is a party, it is mandatory for the courts to first try and refer the parties to settle. If they settle, well, that's the ideal scenario. If not, then of course they can come back to court and resolve the matter. Similarly, under Order 32A, Rule 3, if it's a family matter where things are very sensitive, once again, the parties have the option they in fact don't have the option, but the courts these days require that mandatorily parties give one shot at least to these settlement proceedings. If they settle, then that's great. If not, then of course they can come back to the court. So there are attempts being made to try and persuade the parties to settle their disputes without necessarily resorting to a court of law for two reasons: to save on some time and also to save on expenses required. There is an additional benefit of arbitration, which is the expertise that the arbitrators bring on table. So for example, let's say there are two multinational companies and they have matters where crores are at stake. They may require somebody from the industry who has inside information of the industry. They may require somebody absolutely neutral, impartial, but also equally knowledgeable. So parties control the proceedings and they have an option whether and who to appoint. As far as arbitration is concerned, broadly there are two types of arbitrations. There's the ad hoc arbitration and there's the institutional arbitration. Ad hoc arbitration gives entire power to the parties, so parties can draw up every aspect of how arbitration is going to be governed, both in terms of the procedure, where it's going to be held, what rules are going to be applied, so on and so forth. But that may be too tiresome for the parties. There is room for error, and in light of that, the parties may opt for institutional arbitration. Institutional arbitration simply means that there are some existing institutions in India and around the world which have a proper program laid down. They give you not just the infrastructural support, a list of arbitrators to choose from, but also proper rules that the arbitrators can just directly apply. So if the parties enter into a contract and say that we agree to commit ourselves to so and so rules of arbitration, then once a dispute arises, it becomes easy for parties to put this dispute resolution mechanism into play. As I said, the Indian Constitution itself now wants, under Article 39A, it directs the state to promote justice for every section of the society. This justice, of course, has to be speedy. We also know through a category of cases under Article 21 of the Indian Constitution, which talks about life and personal liberty and dignity, that speedy justice is now considered to be an essential aspect of Article 21. The landmark case on this, of course, is Hamara Kanoon versus State of Bihar, which is a 1979 case where the court said, well, when you're talking about justice, it has to be speedy justice. So while there is a group of policymakers, lawyers, judges who are thinking about how do we make the existing court system more speedy and effective, in the meantime, this parallel system of ADR should definitely keep growing, and we need to train more and more people in India who can take up ADR professionally and help people resolve their disputes without having to go to the court. I hope you found this video useful. If you did, please do let me know in the comment section. Also do share it with your friends and family. Do let me know what are the other topics on which you would like to have an overbroad legal overview. These look like difficult concepts, but they're very simple. It's best to have a broad understanding, and we can always have future videos explaining each of these different four types in some more detail. Thank you for watching. Jai Hind, Jai Bharat.